Recording in progress.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh to Professor Madya Dr. Haji Muhammad Shahnawi bin Muhammad Pirus, and good day to everyone. My name is ROZITAHANA binti ZAINOL ABIDIN, and this presentation is part of the requirement of the individual assignment for INC500 Industrial Relations, Regulation and Cybersecurity. Today, we are going to look at a recent court case, Saharun Zaman bin Barun versus Produa Sales dan Berhad. It is a case that has changed how we look at employee rights in Malaysia. Let's look at the fact of the case. Saharun Zaman, Noramidah and Muhammad Razif were long-time permanent employees at Produa. One day, the company gave them a difficult notice, a difficult choice, an ultimatum to voluntarily resign from their permanent jobs and assign a new temporary 2-year contract with an associate company called NAM. Essentially, they were asked to give up their job security for a short-term deal. When the 3 employees refused to resign, the company took immediate action. They issued transfer notice, but not to a nearby office. They ordered them to move across the country to Kota Kinabalu, Kuching and Kuala Terengganu. The timing was a smoking gun because it looked less like a business need and more like a punishment for staying with Perdua. The employee felt they were being forced out, so they took their case to the industrial court. After looking at the facts, the industrial court agreed with the workers. They ruled that the employees were treated unfairly and awarded them money for lost wages and compensation for their years of service. Produa did not accept this result and appealed to the High Court. This time, the High Court sided with the company. The judge cancelled the awards, saying the employees had not proven that the transfer orders actually broke their employment contract. Finally, the employee went to the Court of Appeal. The judges there disagreed with the High Court and set its decision aside. They ruled that the industrial court was right all along. They reinstated the original awards, officially giving the 3 employees their victory and the compensation they deserve. In the world of industrial relations, a fundamental breach isn't just a small mistake or a minor disagreement. It is an action so severe that it strikes at the very root of the agreement. The employees argued that by issuing an impossible ultimatum and a sudden faraway transfer, Produa had effectively killed the relationship. If the company's action broke the most important part of the agreement, the law says the employee could treat the situation as if they had been fired. This is called constructive dismissal. It's when an employer doesn't officially fire you, but they make things so impossible that you are forced to leave. The second issue is about bad faith or malafide. It's the idea that someone is acting with a hidden dishonest motive. The court had to look past the official HR letters. On the outside, it looked like a normal transfer. But the real question was, did the company actually need these workers in those far-off cities? Or were they just trying to punish them? The employees made a serious claim. They argued that management prerogative, which is the boss' right to make business decisions, was being used like a weapon. They believe this was a backdoor trick to force a long-term staff like them to quit. Why would a company do this? If an employee resigns on their own, the company doesn't have to pay them termination or layoff benefits. By making things so difficult that the workers felt they had to leave, the company could save hundreds of thousands of ringgit. The court had to decide, was this a real business move or just a sneaky plan to avoid paying what the workers were owed? The final legal debate was, should the court follow the strict letter of the contract or the spirit of the relationship? The High Court took a strict view. If the contract says the company can transfer you, they have the absolute right to do it. period. However, the Court of Appeal looked at Section 35 of the Industrial Relations Act, which is the conscience of Malaysian labour law. This law requires courts to act with fairness and common sense rather than just following technical rules. The Court of Appeal decided that every contract has an unwritten rule of reasonableness. You cannot send someone across the sea with only 3 days' notice and no work permit and call it legal. This shift from strict contract test to a reasonableness test is what ultimately won the case for the workers. The Court of Appeal found that Perdua's actions were not just a minor mistake. They were a major breach that hit the very root of the employment contract. The judges used a powerful legal phrase. They said Perdua had evinced an intention not to be bound by the contract. In simple terms, this means the company acted in a way that showed they no longer respected the agreement they had with their workers. Because the company broke the foundation of the relationship, the employees were right to leave and claim constructive dismissal. In the end, the Court of Appeal delivered a clear and unanimous win for the workers. They allowed all 3 appeals and completely cancelled the High Court's earlier decision. Most importantly, they reinstated the original awards from the Industrial Court. This meant the 3 employees were finally recognized as victims of unfair treatment and were granted the full compensation they had been fighting for over the last 7 years. Let's begin our analysis with the star of this case, the contract test. Historically, the contract test was often seen as a cold, mechanical tool. However, this judgment humanized that test. The Court of Appeal pointed out that in Perdua's own contract, the transfer clause included the word as reasonably directed. This is a legal game changer. By including that word, Perdua turned reasonableness from a vague moral idea into a binding contractual term. In the article by Donovan and Ho, they also agreed that with the Court of Appeal that the test for constructive dismissal remained the contract test. They also agreed with the inclusion of the phrase as reasonably directed by the company in the transfer clauses of the employee's contract meant that the employer had a contractual obligation to ensure that any transfer decision met a standard of reasonableness. This meant that reasonableness was not just a mere consideration, but a contractual term. The court ruled that you cannot act oppressively or impossibly and claim you are following the contract. If your directive is unreasonable, you have breached the contract. This bridges the gap between the strict contract test and the reasonableness test, creating a massive shield for employee protection in Malaysia. Our next analysis is Section 35 of the Industrial Relations Act. The Court of Appeal praised the Industrial Court for acting as a court of conscience. The High Court was criticized for being too mechanical and stuck on legal technicalities. But Section 35 mandates that the court must look at the substantial merits of a case. For example, Perdua ordered a transfer to East Malaysia without securing work permits. The Court of Appeal was clear. An employer cannot use its powers to force an employee to commit a criminal offense by working illegally. That can never be a reasonable directive. This reaffirms that equity and good conscience are not just suggestions, they are the law. While we celebrate the 2025 decision as a victory, we must critique the procedural burden it took to get here. These employees entered a legal marathon. From the moment they were issued those 3 days transfer order in late 2018, it took 7 years of litigation to reach finality. For an average worker, fighting a corporate giant like Perdua through the Industrial Court, then the High Court, And finally, the Court of Appeal is a feat of extreme endurance. Most employees would have surrendered after the High Court reversal. Is the path to winning a case like this too long and too costly for the average worker? The second point of critique is the high legal threshold required to prove mala fide or bad faith. The fact that a High Court judge, a senior legal mind, originally overturned the Industrial Court Awards shows us how deeply ingrained the concept of management prerogative is in our system. The High Court's initial ruling suggested that as long as an employer has a right on paper, the court should not question the motive. This creates a dangerous barrier. In most cases, bad faith is subtle. It doesn't always leave a paper trail. If the Court of Appeal had not stepped in to correct this mechanical approach, many employers would have felt emboldened to use transfers as a tool for quiet firing. In this case, the employees won because there were three smoking guns evidence so undeniable that it could not be ignored. These were the impossible 3 days reporting window, the lack of work permits for East Malaysia, and the immediate timing after a refused ultimatum. But we must ask ourselves, what happened to the employee who is transferred with 30 days notice, but whose motive is still to force them out? Without these extreme obvious errors by the employer, would the court still have found a bad faith? This suggests that the legal system is still heavily weighted toward the employer initial right to manage, requiring employees to provide near-perfect evidence of malice before a court will intervene. This case forces us to critique the current state of employment contracts. Why must an employee wait for a court of appeal to rule that reasonableness is a requirement? This judgment suggests that the law needs to move faster toward recognizing an implied term of mutual trust and confidence in every single contract, regardless of the wording. Management prerogative should never be a shield for oppression. As industrial relation practitioners, we must advocate for a system where equity and good conscience are the starting point of a contract, not a final resort after 7 years of fighting. Finally, we must address the critique from the perspective of HR practitioners and employers. This judgment is a stark wake-up call. For decades, many HR departments operated under the assumption that management prerogative was a blank check, a sovereign right to move employees like chess pieces. The Court of Appeal has clarified that this power is not absolute. While the employer still has the right to manage their business, that right is now tethered to the requirement of good faith. In the eyes of the law, a management right exercised with a punitive motive is no longer a right at all. It is a breach of contract. This forces a shift from a rule by contract to management by reasonableness. Let's look at the logistic. In this case, the 3-day reporting window was a fatal error for Pro2. The court was very clear. If you are restructuring, your timeline must be humanly possible. 72 hours to move across the sea to East Malaysia is not a notice period. It's a forced exit. When HR sets an impossible deadline, they are essentially signaling to the court that they want the employee to fail. Critically, this case teaches us that if the notice period is so short that it causes oppressive hardship, the court will look past the transfer order and see it as a disguised dismissal. For HR, the lesson is simple. If you will not be able to move your own family in that time frame, don't expect your employees to do so. Moving forward, the operational requirement will be under microscope. In the past, an employer could simply say, "We need you in coaching for business reasons," and the court would rarely dig deeper. Now, thanks to this ruling, the court will ask for evidence. If you cannot prove why that specific employee with their specific skill was needed in that specific branch at that specific time, the court will likely find your motive was punitive. If the transfer happens immediately after a dispute or a refused ultimatum, the burden of proof shifts heavily against the employer. This means HR must now build a paper trail of necessity for every transfer to survive the contract test. To avoid the 300,000 ringgit mistake Produa made, HR departments must evolve. To pass the contract test today, every transfer must be supported by clear business justification, document the specific skill gap or project requirement at the destination. A reasonable relocation window. A standard practice should move toward 14 to 30 days, especially for interstate or cross-border move. And the third one is consultation. Engaging with the employee about their personal hardship. For example, like OKU status or family welfare. This isn't just about being nice anymore. It is a legal safeguard to show the company acted in good faith. We must conclude that this judgment doesn't take away the right to manage. It simply requires that management be performed with integrity and equity. On this slide is the list of references for my presentation and case study. With this, I end my presentation with Assalamualaikum and good day to all. Thank you.